Hi, everyone. Welcome back to the channel. Thank you for tuning in. I would say that it's great to be here and happy Wednesday and all that happy stuff, but it's actually not a very good day because, well, quite frankly, we, the Second Amendment community, lost at the Supreme Court. The case is the Vanderstok v. Bondi case, previously known as the Vanderstok v. Garland case. This is the one challenging the frame and receivers rule, or the ghost gun rule. And you know what bothers me the most about this one is that there are multiple things in here that are just, quite frankly, sloppily done. And one of the things that, as an example, bugs the heck out of me is multiple times in this document, it is stated that these things can be readily converted in a couple minutes without specialized tools or expertise. And as someone who has completed multiple of these things over the course of their career and is a pretty technically savvy person, I would say that that is just a blatant misrepresentation of what those products do. And it's just a claim that was made by the government, and the Supreme Court just accepted it and just ran with it. They didn't do any kind of like thorough analysis on whether or not that was actually the case. Well, as someone who has been there, done that, because I'm assuming that none of them actually have, it's just a lie, and they just ran with it. And that's the thing I think that bothers me the most about this. So, quite literally, the claim is, it was a facial challenge that the Gun Control Act covers the readily convertible weapons parts kits, and I kid you not, the justification for this is gonna blow your mind. The justification is that if you go to IKEA and buy like a table kit, you might call that a table even while it's still in the box. They literally wrote that. I don't think that that hunts, and I think there are some clear distinctions between a kit that requires cutting and drilling and all that sort of stuff, and something that you take out of the box and just kind of like put the fasteners together with the tools that they assembled. I would also point out that that furniture that you assembled is crap and doesn't work very well. This video was brought to you by Medical Gear Outfitters. They are my go-to stop for all things medical. It doesn't matter whether you need something that just holds a bunch of Band-Aids and maybe some aspirin or something like that, or if you need an actual trauma kit. If you don't have a trauma kit in your house or in your vehicle, then I highly suggest that you go check our people out at Medical Gear Outfitters, and they offer all of you a discount. You can find all of that information over at the affiliates page and all the relevant places, and use that to great effect. I'm disappointed in this ruling by the Supreme Court, because even some of the justices that we assumed were going to rule the other way basically said it's okay because, like, for instance, Kavanaugh said, well, the government has to prove that you knowingly violated the law. Especially for somebody like Kavanaugh, should be more understood that it's actually not even the ultimate conviction. It's the the process is the punishment when it comes to many of these things. And the ATF and some of these executive agencies rule through the power of fear, that you are going to have to, if you do a thing, go and defend yourself to the tune of hundreds of thousands of dollars. Even if they ultimately lose, you ultimately will be bankrupt by the time they are done with you. And whether it's constitutional or not, whether it's legal or not, that is the mechanism that they use to enforce these laws, whether they have the power to do it or not. And this is just one instance of that. It's not necessarily the actual thing that that we are concerned about. It's the way the agency exercises power, and the Supreme Court in this instance in the words of Thomas, blessed the government's ability to overreach. All right, so I'm off that one now. But the second thing that I wanted to point out that makes me very uncomfortable is this notion that because of technological advancement, that somehow curtails my rights. Just because we have innovated, and the march of technology has always been, since we picked up the first rock to where we are today, has always advanced. Because of that perpetual motion forward, it somehow curtails a natural right. Gorsuch writes, in recent years, however, we have witnessed profound changes in how guns are made and sold. When Congress adopted the GCA in 1968, the milling equipment, materials needed, and designs were far too expensive for individuals to make firearms practically or reliably on their own. With the introduction of new technologies like 3D printing and reinforced polymers, that is no longer true. Today, companies are able to make and sell weapons parts kits that individuals can assemble into functional firearms in their own homes. So what? That doesn't mean shit. You could just make your own bow and arrow. You've always been able to do that. You could just go make your own spear. You could make your own your own knife. You could do flint knapping. Like, I don't understand how a natural right that is enshrined in our Constitution, like literally the second thing we wrote, has anything to do with the advancement of technology. And in my opinion, the justice is playing quite close to the flame when it comes to the concept that these rights can be curtailed because, well, we live in a different time. That makes me very uncomfortable, and if it doesn't make you uncomfortable, even if you're a lefty, I don't think that you're quite paying attention, because what can be done to one right can be done to any other right. So we're a little bit short on time, so I got two other things I want to really go at. Now, at the end of the opinion, it basically says, hey, there is a delegation of authority basis here that the ATF can make this rule. Whether it applies to this design or that design or whatever is a question for another day. Congress delegated the authority to the executive branch to be able to figure out how to write the rules. I guess what I would say in closing today is, all right, Trump administration, we told you that you should sit there and let some of these things go to the Supreme Court and see what they say. Well, now they have come back with the government can infringe. Well, now the onus is on you to now rescind that rule. This is your opportunity to shine. You're already in the negative on the Second Amendment stuff. This should be a very easy thing. You basically should just go to your desk and write, the frame and receiver rule is hereby rescinded. And then we can make this thing go away and at least make them completely start over with this thing. The ball is in your court, sir. Go and do. This one will be going in my What Trump Should Do playlist.